All right, so we'll get underway. Good afternoon, everyone, and thank you for joining us for another one of our free MAG educational seminars. Today we have Sach Fernando and Tyen Redmond from Maxiom Injury Lawyers, and the session today is about a Workcover update of the recent changes to the Victorian Schemes. Both Sach and Tyen are well-known and respected lawyers with a wealth of experience in the Victorian scheme. MAG has worked with them for many years now, and we're proud to have them presenting today on this very topical seminar. So may I ask you to all keep yourselves on mute so that no background noise interferes with the quality of the recording. You'll be able to unmute yourself and ask questions at the end of the presentation, or you can type them into the chat box if you need to leave or you don't want to speak up. The recording will be sent out to you within a day or so, along with the slides. And on that note, without further ado, I'll hand over to you, Sach and Tyen. Thank you so much for giving us your time today to deliver this session. Now over to you.
Thank you, Jess, and thank you, everyone. Before we start, I'll acknowledge the traditional owners of the lands on which we meet and pay my respects to their elders, past, present, and emerging. Today, Tyen and I are hoping to speak with you about the modernisation of the Workcover scheme. The changes were implemented in March of this year, and admittedly, we are yet to see the full effects of those changes, but they have had some devastating consequences to injured workers. So I will speak about the initial entitlements, and then Tyen and I will both discuss how those entitlements have changed. So insofar as entitlements are concerned, once the Workcover claim has been accepted, the next slide, please, an injured worker is entitled to their weekly payments and medical expenses. So with respect to weekly payments, an injured worker is entitled to receive 95% of their pre-injury wages for a period of 13 weeks. That then drops to 80% and will continue typically for 130 weeks. Now, the test for receiving weekly payments during that time is whether or not the injured worker can do what they used to do, whether they can perform their pre-injury work. And so long as they can establish that they can't do even one aspect of their pre-injury work, they have that entitlement to 130 weeks of payments. And those payments are determined by reference to 12 months of earnings prior to their injuries, worked out on an average. So we call that the pre-injury average weekly earnings, or PRW. When it comes to medical expenses, injured workers are entitled to any medical expenses, medical or associated expenses that are referable, that are needed and referable to their claimed work-related injuries. Now, going back to weekly payments, prior to 31st of March this year, in order to get weekly payments post 130 weeks, our clients had to demonstrate that they had no current work capacity indefinitely. That is, they can't do any suitable employment into the reasonably foreseeable future. And it is that entitlement that has been most impacted by the change to the Workcover legislation. In addition to weekly payments and medical expenses, injured workers are also entitled to 2 lots of lump sums. That's typically where us lawyers get involved. There are the first entitlement, as we call it, is the impairment benefit, which is a modest lump sum of money that is determined by reference to the injured worker's level of impairment. Now, for physical injuries, the assessment is done in line with the AMA guides. With respect to psychiatric injuries, the assessment is done in line with the guides to the evaluation of psychiatric impairment for clinicians, or the GEPIC, which looks at 6 criteria: intelligence, thought, judgment, perception, mood, and behaviour. And for a psychiatrically injured worker to receive an impairment benefit, they will need typically an average of 3 out of 5 for each of those categories to get to that 30% threshold. If they do, they get something around $80,000. The bigger lump sum is the entitlement to common law damages, and common law damages are awarded if the injured worker can demonstrate permanent serious consequences of their injuries. And we have to assess whether the consequences that the injured worker suffers from can fairly be described as more than considerable or marked. If they do, they are awarded a serious injury certificate, and then in order to receive common law damages, they have to demonstrate negligence. As much as I love talking about common law damages, the purpose of this presentation is to talk about the scheme modernisation. So now I'll hand it over to my colleague Tyen to discuss the changes.
Thanks for that, Sach, and good afternoon, everyone. Thanks for having us on this stream to chat this afternoon. So these are quite recent changes, and as Sach described, it kind of had some immediate or quite immediate consequences for a certain subset of work cover claimants, and the consequences of that will only become more apparent as time passes. We're still kind of grappling with the effects and coming to terms with that. It's also changed entitlements for people who have suffered a mental injury going forward in terms of what the eligibility requirements are for them under the scheme. Now, before I dive into the specifics around the changes impacting the entitlement to mental injury claims, I just wanted to touch on, I guess, some of the background or you know, the foundation behind these amendments. So it was financially motivated from the perspective that the Workcover scheme was struggling to afford the ongoing costs associated with managing and paying for entitlements under the scheme. So it was a financially motivated reform to preserve the integrity and the ongoing basis of the scheme. Now, you know, naturally, we do have some criticism of the changes. Okay, we understand the commercial realities of it, but at the same time, as you'll see with some of these changes, it does move the responsibility just from one public purse to another potentially, and so it's quite a blunt set of instruments they've introduced here that are trying to be one size fits all, which is generally not the best way of doing things. So look, I mean, we are a bit critical of it because it does put some of our most vulnerable clients in very difficult positions. But you know, we have to deal with the realities, and it will only be over the course of the next probably 12 months to 2 years that we see some of these new definitions and provisions in the legislation interpreted by the courts and disputed to see the full impact of some of these reforms. So as I said, I'm going to touch on the impact on entitlement to claims for mental injuries. So as of the 1st of April this year, if you suffer a mental injury in the course of your employment, there is now a new definition you have to meet in order to have an eligible claim. As you'll see there, it talks about the injury has to be one that causes significant behavioral, cognitive, or psychological dysfunction. In a broad sense, we understand what significant behavioral, cognitive, or psychological dysfunction can potentially mean, but the legislation doesn't define what the thresholds are there. What is significant? What is a behavioral dysfunction? What is a cognitive dysfunction, and so forth? So we don't have a great deal of guidance there as to how the insurers are going to apply these definitions. And beyond that, if they are ultimately disputed, what the court's interpretation is ultimately going to be in relation to these definitions as well. So it does create a element of uncertainty around who does and who does not meet that particular element of this new definition. The second part you'll see on the slide there is that there's now a requirement that a medical practitioner has to form a diagnosis in accordance with the DSM-5 or any subsequent version of those diagnostic manuals that come about. Now, that's got two elements to it. As far as we understand, based on the definition of medical practitioner in the legislation, that means it's got to be a doctor and can't be a psychologist that's making that diagnosis. And if you don't have a diagnosis that is made in accordance with the DSM-5, then that is a basis for the claim and liability for that claim to be rejected. Now, my understanding as a layperson is that it can be there can be more hurdles to meet with some of the definitions of different injuries or illnesses under the DSM-5 criteria. So it may be more time consuming, there may be more testing involved, it may not be something that can be diagnosed straight away as well. So there's a tension between needing to meet this requirement of having a diagnosis in accordance with this requirement, and how long does the injured worker have to wait before a claim can be potentially lodged, particularly in situations like PTSD, where there has to be presenting symptoms for a period of times, and other illnesses or psychological injuries of that nature. It is also now a requirement to show that a mental injury was predominantly caused by employment. Now, prior to this, a mental injury, we only have to establish that work was a significant contributing factor. So the bar has been lifted here to show that we've got to meet a higher, relationship or a nexus or with the workplace. Now, once again, the question of what does predominant mean? What is the test that we're ultimately being asked to meet in relation to that? That remains uncertain. There is language around predominant in relation to injuries suffered as a consequence of reasonable management action. The law says that if you suffer an injury wholly or predominantly as a cause of reasonable management action, then liability can be rejected. And there's, legal decisions around what that means. But in this context, it's yet to be tested and it's yet to be understood. So these are all areas where over time, there will be, possibilities where these matters will be litigated, and what the standard is that has to be met will be better understood as that becomes clearer. This new definition of a mental injury applies to a frank, new, fresh injury, but also to recurrences, aggravations, accelerations, exacerbations, or deteriorations of a pre-existing injury. So if you've got a worker that had an underlying, history of depression, and they've been bullied at work, and they've suffered an aggravation to that pre-existing condition, then we have to show that it's still causing a significant behavioral, cognitive, or psychological impairment, and that it meets the DSM-5 criteria in order to get the claim accepted. It applies to both primary and secondary psychological injuries. However, it does not apply in terms of that diagnostic requirement or that significant requirement does not apply to the eligibility for provisional payments, which was an amendment probably introduced a few years ago, where for someone who suffered a mental injury at work can access treatment for a period of 13 weeks, irrespective of whether the claim's ultimately rejected or accepted, say for a few limited exclusions under the legislation. They've also carved out a couple of particular scenarios and put some limits in some regards and some protections in others. One of the limitations is in relation to injuries connected to stress or burnout. So if a mental injury is predominantly caused by work-related stress or burnout that has arisen from events that may be considered usual or typical and reasonably expected to occur in the course of that worker's duties, then they don't have to accept liability for the claim. Okay, what is considered predominant in that context as well is going to be tested. What is work-related stress? What is burnout? And what is usual or typical and reasonably expected to occur are all things that aren't defined in the legislation. These are things that will be tested. These are things that will have to be interpreted on a case-by-case basis. And they're quite hard things to kind of quantify, or it can be very, very case-specific, the circumstances. And one person's role in an organization may be very different to another's, depending on, I guess, the nature of their individual position or job description. So these are hard things to kind of grapple with and advise clients on. And it does introduce, and as you'll see with a lot of these changes, it does introduce a greater element of uncertainty as to when a worker suffers an injury at work, what is the likelihood that they're going to be able to access entitlements under the scheme? You'll also see there on the slide there's an exception in relation to traumatic exposure to traumatic events. So if a mental injury is predominantly caused by the exposure to such events that may be considered usual or typical and reasonably expected to occur in that type of work, then they will be accepted. So this is kind of, broadly seen as a carve out for, the kind of first responders, police officers, firefighters, ambulance officers, people of that nature, where it is regrettably part and parcel of the work that they do that they will be exposed to some kind of trauma in the course of their duties. I've prepared a couple of examples on this in these PowerPoints to just kind of illustrate a couple of cases where someone in the past may have had entitlements, but they won't because of these reforms. So in this example, Peter works at a service station. One night, the store he's working in at the servo is robbed by armed bandits. Because of that traumatic experience, Peter continues to have nightmares and panic attacks. He sees his GP. He's told he's suffering from stress and anxiety, but there's no reference made to the DSM-5 criteria when he's given his medical certificate and on the paperwork is provided in connection with his claim. Peter lodges a Workcover claim. Now, historically, in those circumstances before these amendments, his claim would have been accepted because it's quite clear that he's suffering an injury arising out of his employment, and he's got a diagnosis, and off we go. We'd lodge the claim, and you'd be, almost certain that claim would be accepted. Now there's a real risk for Peter in such circumstances because the Workcover insurer will likely pick up that he doesn't have a diagnosis in accordance with the DSM-5, and therefore it doesn't meet the definition of what a mental injury is, and that gives them grounds to now reject the claim. Now, that's not Peter's fault that he doesn't have a diagnosis in accordance with that. And what we've found, and Sach, I imagine you'll agree with me, but in other discussions with health practitioners that we've had around these amendments, we found that a lot of people aren't aware that these changes have even come in. And it's quite shocking when we've spoken to some GPs. They're like, we haven't been consulted about these changes, so we don't know. We weren't aware that we had to meet these new requirements, and it's important because people's livelihoods can be directly affected by some of these changes. I've got one more example in relation to the mental injuries claim, and this is an example of Claudia. Now, Claudia works. Yes.
Before we Claudia, I guess one thing I also wanted to emphasize is the difficulty that our clients have obtaining, getting a referral to see a psychologist to do that DSM-5 diagnosis. GPs are very busy, and therefore it's not often the case that they will consider the criteria in the DSM-5 when giving a diagnosis. And unfortunately, and of course, they're medical professionals, they can provide their diagnosis, but unless it's evidence that it's been assessed under the DSM-5, the claim could well be rejected. And so thereby further delaying the determination of our clients' claims, which is very unfortunate because our clients are quite often very psychiatrically unwell.
Yeah, and just on that point as well, just in terms of the feedback that we get from clients in terms of trying to get a referral to see a psychiatrist as well. I mean, the word we get from our clients is it's a number of months. It can be 6 months or more waiting to get an appointment. I can think of one client I spoke to yesterday who has just got an appointment for November. That's the earliest he could get in. Now, if this is a complex case where the GP wants to lean on the expertise of a psychologist or a psychiatrist to assist with that diagnosis, well, that's going to prolong this whole process and may lead them to have to be without income, without someone funding their treatment, but on what they can access under Medicare for a period of time. So in my view, I don't think that's leading to great outcomes for injured workers, especially trying to get them back to work in a timely way, which is the optimal goal in these circumstances. So I'll just touch on this Claudia example. So Claudia's got a lovely job down the coast, working at a caravan park. During the summer school holidays, her workload increases dramatically, as you can imagine. Everyone's flocked down there for a holiday. She's working overtime. She's struggling to keep up with the demands of the job. She thinks management should be putting on more staff during these peak periods to reduce the workload and help out so she's not constantly under stress. They're not responsive to this. She lodges a Workcover claim on the basis that she's got burnout. Now, under these new changes and the carve out for burnout or work-related stress, it's going to be arguable that that injury is predominantly caused by events that would be considered usual or typical and reasonably expected to occur, given the seasonal nature of a job. And it's probable in that circumstances that the Workcover insurer would turn around and reject that claim. Okay. In the past, that claim would have been accepted, and she would have been able to access entitlements while she got treatment, got better, and before she got back to work. Now, Sach, I'll hand over to you to talk about these post 130-week reforms a bit further.
Thanks, Ty. I touched on this earlier, everyone, in terms of the entitlement to payments beyond 130 weeks. The old test used to be that the injured worker would need to demonstrate no work capacity for suitable employment indefinitely, into the reasonably foreseeable future. So what we would typically do for a physical injury case is we would send our clients to an occupational physician to consider factoring in our clients' age, qualifications, transferable skills, the injury, limitations caused by their injury, medication, effects of that medication. Can they perform suitable employment? And if not, is that indefinite? Which was a very, very high threshold. And we did see a lot of our clients being terminated from weekly payments at that stage. But often those clients who were a bit older and ages up, that's very subjective, but say someone was a migrant who who's in their mid-50s, has only worked in the factory all of their lives, and has suffered a disc bulge, and that's become chronic. They were likely to receive weekly payments post 130 weeks until the age of retirement. Now, what this new legislation has imposed is an additional requirement that the injured worker have an impairment of 21 or more percent. The slide refers to more than 20%, so 21% or more. So just going back to that example of the migrant worker in their 50s suffering from a disc bulge, there is no chance that that individual will get to 21%. If they have a disc bulge, typically under the AMA guides, they will attract an impairment rating of 5%, and that'll be bumped up to 10% to meet the threshold. However, it is very short of the 21+%. That's now a necessity to receive ongoing payments of compensation. So next slide, please. It's very unclear at the moment as to how these assessments will take place, and we have great concerns about the timing of these assessments, particularly when our clients' injuries have not stabilised. Just touching on some of the dot points that you see before you in the slide, to get to the 21% threshold, the physical and psychological injuries cannot be aggregated. The secondary psychological injuries don't count at all. Ty, please correct me if I'm wrong. My understanding is that if there is primary psychiatric, that can be combined with the physical.
No, it can't. Not under these reforms. It's either physical alone or psychological alone. It can't be both. Yes.
Okay. And going back to that example that I touched on with an older gentleman who has suffered a back injury, that may have then become, they have subsequently developed a secondary psychological sequelae, which is very, very common in these types of matters. As a result of the limitations, people can't work and provide for their families, they've lost their enjoyment of life, they get depressed. Even if their psychiatric impairment was assessed, there is no chance that those individuals would attract a primary impairment score. They might attract a secondary impairment score, but as you just heard, that can't be aggregated to get to the 20%. Equally, even if they faced a primary trauma, say, for example, they were a nurse at a psychiatric facility and they were violently attacked, they develop a psychiatric condition, let's call it major depressive disorder or post-traumatic stress disorder, there is no guarantee even that individual under the criteria of the GEPIC would reach that 21% threshold, because it's a very, very high threshold to meet. Tyen, did you want to talk about the reference to relating it to one or more compensable injuries?
Absolutely, Sach. So the law now says that the injuries have to arise out of the same event or circumstances. Now, this is another example of where it's currently unclear how that's going to exactly be interpreted. Now, probably the majority of individuals that we act for suffer an injury in one discrete event, particularly with physical injuries. You know, they fall over at work, they get run over by a forklift, whatever it might be. But there is a significant group of individuals where it's not one single event. It's a series of repetitive movements or repetitive duties or doing the same thing week in, week out that causes, you know, the disc bulge in their lower back or the epicondylitis in their elbows and things of that nature. So we just don't know at the moment, because we haven't had the flow through of these cases being reaching this point, having these decisions made and having the possibility of disputing them, because they're all still trickling through the system at the moment, to know what the courts are going to say ultimately in relation to this, and even what the Workcover insurers are going to say, as they determine these ongoing entitlements post 130 weeks. So once again, uncertainty. It's not friendly to the injured person that's the one suffering here. In addition, sorry, Sach, I was just going to speak about it has to relate to one or more compensable injury. Okay, so they've kind of introduced a limitation here in terms of what they will consider at that point in terms of assessing the degree of whole person impairment and what they factor in. So you'll see on the slide there, it's talking about an injury where liability has been accepted or established and the worker is or has been entitled to compensation during the second entitlement period. Okay, now you might have a worker who's got an injured right dominant shoulder. They develop a consequential injury to their left shoulder because they're doing everything around the house with their left arm. You have workers that develop gastrointestinal symptoms because of being on medication for prolonged periods of time. You have also workers that, because of the medication they're on and the types of opioids and other pain medications they're on, they develop things like sleep apnea. Now, we have to now be very conscious of when those injuries come up, first and foremost, but whether the insurer accepts them during this second entitlement period or not, and also whether they're paying compensation towards it. Okay, so are they paying towards the reasonable medical and life expenses in connection with these subsequent injuries? So that is something new that we're learning to grapple with as well following these changes.
Thank you, Tyen. Next slide, please. So prior to the reforms, if an injured worker underwent any surgery after the 130-week period and the Workcover insurer funded the cost of that surgery, then they could theoretically apply for the reinstatement of their weekly payments based on there being a material change, that being surgery and the incapacity flowing thereafter. Now, what's happened now is, subsequent to the changes, impairment can't be assessed, even if there is a deterioration of the injury or a development of a consequential injury after the assessment. So again, even if the surgery goes pear-shaped, it is difficult for, perhaps impossible for our clients to get back on payments.
I'll just add to that, Sach, as well, is even where historically, a worker might have to have, say they've had an arthroscopy at some point, but they've come to a knee replacement that's well after the 130 weeks. in the past, in limited circumstances, they could get weekly payments for, I think it was 13 weeks to have the surgery, have time to rehabilitate and then transition back to work. That now is also limited by this requirement to have a 21% or more whole person impairment. So, it disadvantages people to some degree, the ones that are trying to maintain their work capacity to get the treatment they need to remain in the workforce and remain self-sufficient, because they will push it off for as long as possible because they won't be able to access payments to provide them an income during that difficult period around the surgery. So that's quite a significant change and a bit of an overlooked one in terms of the coverage of this so far in my assessment.
Agreed. And the reality is someone who's had an arthroscopy might get 4% impairment, but someone who has a total knee replacement might attract something quite substantial. I mean, they could potentially get 20 or more % following an arthroscopy, depending on a replacement, depending on their on how well their recovery goes. Now, moving on to an example of Sheng. Sheng was a labourer for a bricklayer, suffers a lower back injury moving a heavy wheelbarrow. He hasn't worked since. His doctors all accept that he doesn't have a work capacity. He has no current work capacity, which will continue indefinitely. As he approaches 130 weeks, he attends an impairment assessment and is found to have 20% whole person impairment, which is a very high impairment, might I add. He sees another independent medical examiner who agrees that he can't work and is unlikely to return to work. Under the old regime, he would have received weekly payments post 130 weeks until the age of 67, being the age of retirement. Now, following the reforms and the modernisation of the scheme, because he's under 21%, his weekly payments will come to an end at 130 weeks. Ty, did you want to speak to the next example of Ash?
Yeah, absolutely. So in this example, I prepared Ash as an experienced website developer. One morning, she slips on a spill. Someone had spilt their coffee on the floor in the office. She falls over. She injures her right hand and wrist, requiring surgical fixation. Her recovery doesn't go to plan. She develops complex regional pain syndrome. And because she's using her left hand and arm so much, she develops a consequential injury to her left hand as well. She attends an independent medico-legal examination, who accepts that she's got no current work capacity, and that would likely continue indefinitely. However, her impairment is assessed as 12% physical and 9% secondary psychological. Once again, under the old regime, she would have remained on weekly payments after the second entitlement period, so post 130 weeks. Now, as her impairment does not exceed 20% for physical or the primary psychological, her weekly payments would end at 130 weeks. Now, in both these examples, for Sheng and Ash, we've got people that it's accepted that they can't return to work indefinitely. So it's not like that they're going to have an abundance of options available to them to obtain income. And probably, in most of these scenarios, the unfortunate reality is they turn, as I said earlier, to a different public purse in terms of having to rely on Centrelink benefits of this nature. So part of my critique of these reforms is that it's a cost saving from one area of a government budget, and it shifts to another one, which is a little bit, I don't want to say disingenuous, but it doesn't resolve the issue in totality, I guess, is the practicalities of it all.
And I mean, you all can derive from that. At the end of the day, our clients who can't work but are kicked off the Workcover scheme will most likely be eligible for Centrelink benefits, and so they will turn to Centrelink, and they'll most likely get on the DSP or job seeker. So, in our respectful opinion, impairment should never determine capacity for employment. And as we go to the next slide, let's talk about some of the practical impacts of these changes to the scheme. Multiple independent medical examiners may now be required to assess injured workers' capacity as well as impairment. Now, one of the issues that we're seeing, particularly in recent times, is the unavailability of independent medical examiners who are chosen exclusively by WorkSafe, not the Workcover insurers. Whenever we push the Workcover insurers to organise an independent medical examination, we are told that it is out of their hands, that it's WorkSafe who are deciding which independent examiners will assess our clients. And so there's a shortage of independent medical examiners. And when there's a shortage, the assessments can't be done until the availability of one. And what we have seen in recent times is that our clients' claims are being rejected. And in the rejection notice, there is reference to the fact that claims being rejected, but we've organised an independent examination and we'll reassess the entitlements after that examination. Now, during that time, our clients can't work. They have to go through the dispute resolution process, which is requesting conciliation, having their matter listed for a conciliation conference. And then inevitably, we might get to a conciliation conference and the independent medical examination still hasn't been scheduled. So that whole process is further delayed. And usually at conciliations, if it's a medical dispute, for example, if it's to do with the injured worker's capacity for employment, the conciliation officer has jurisdiction to refer the matter to the medical panel. They may not do that until the independent examination takes place, because again, there are significant delays at both conciliations and the Workplace Injury Commission, which is where the conciliations take place, and medical panels. We're also concerned about the lack of legal representation at the time decisions are made regarding entitlements. Now, it's not always the case that someone injures themselves and comes and sees us lawyers. They often come to us when there is an issue. And if we are involved from the outset, we are able to guide our clients in terms of what the law is, and if, for example, we are initiating the impairment claim, we would be adding secondary injuries to maximise their whole person impairment score. Ty touched on the gastrointestinal issues, which is a common byproduct of taking anti-inflammatory medication, pain medication. It causes upper gastric reflux. Now, if we're involved, we would be claiming that injury as well as any other secondary injury, including secondary psychological injuries, to really maximise the injured worker's entitlement to an impairment benefit. And the reason for that is, in some instances, our clients have no common law prospects, purely because they won't prove negligence as against the employer. But a lack of legal representation means that those injured workers don't have that opportunity of having someone ensure that their impairment claims are adequately set up. Next slide, please. Now, I touched on conciliations and medical panels earlier. In my entire career, and I've been in the jurisdiction for nearly 15 years, I have never seen so many delays at conciliation in getting a conciliation date and at the medical panel. So the Workplace Injury Commission, what happens is we would request conciliation. The Commission will set down the matter for a conciliation conference. Historically, it was within about 4 to 6 weeks. Now it's 10 plus weeks. Ty, would you agree that has that been your experience as well?
Yeah, the conciliation service just actually released the data to say that it's now in excess of 100 days from lodgement to conciliation conference.
Which is extraordinary. It's an extraordinary delay for injured workers to have to wait for their matter to even be heard by the first point of dispute resolution. Then, if you do get to a conciliation and the issue is, for instance, causation, was employment a significant contributing factor? Does the injured worker have a capacity for employment? Those disputes could go to the medical panel. Now, what we're finding is that there are significant delays in getting a date for the medical panel assessment. For those that are not in the jurisdiction, the medical panel is an independent tribunal of doctors established to decide on issues of medicine, and they are perceived to be genuinely impartial and independent. We refer a lot of cases to the medical panel. It's a very efficient, cost-effective way for our clients to have some of these issues resolved. But now they have delays in first having their matter heard, and a further delay in having their injuries assessed by an independent panel. And of course, if the matter can't be referred to the medical panel, what usually happens, and those are cases which involve factual issues as to the cause of injury, those matters would receive what's called a genuine dispute certificate at conciliation, which permits the injured worker to litigate their matters at the magistrate's court. I have in recent times, after a very long time, been issuing a number of magistrates' court proceedings, but of course, this comes at an expense to the injured worker. Litigation amounts to legal costs. Higher the more substantial the litigation, the greater the legal costs, and all to get something that they are entitled to under the legislation, which has now been made very, very difficult. So for those who are in attendance, I trust that you can probably sense a bit of frustration as the plaintiff lawyer from two plaintiff lawyers, because we're very passionate about what we do and in protecting the rights of injured workers. But this is the current state of the scheme. It's disappointing that this modernisation was introduced by a Labor government out of all governments. It comes at the detriment of some of the most vulnerable members of our society, injured workers. Happy to take any questions, and equally, if you don't have time for questions now, our contact details are on the last slide. Please do feel free to reach us by email or by phone.
I was just going to mention, Sach, as well, just something that we overlooked is that the changes applying to the termination of weekly payments for 130 weeks are retrospective as well. So it didn't only apply to new claims lodged after the 1st of April this year. It applied for everybody, including people on existing claims. Now, that had an immediate impact on a number of our clients personally, and more broadly across the scheme as a whole, because normally you have 3 months notice of before you hit the 130-week mark to say your payments are going to stop. Here's your options to dispute. It gives you time to make plans about what you're going to do for when the income stops. We had some clients who had received the decision to say that their payments were going to continue post 130 weeks. The reforms came in. They got a new notice saying you no longer meet the requirement. Your payments are going to stop in a matter of weeks. So they've got no time to even start the process of going to Centrelink to try and get some income coming in. It was an understanding that this was an entitlement under the scheme. So when we initially advise clients, you talk about, this is the test, this is what it is. And to have that change quite suddenly and not very clearly communicated to injured workers, we wrote to all our Workcover clients and said, hey, we're giving you a heads up. This is what's happening. Talk to us about it if you're concerned. If they make a decision of this nature, speak to your case manager as well to get some clarity as to whether this impacts you. So it had an immediate effect on some people. And I know that from some of my clients individually, it went from being a conversation saying, all right, 130 weeks is coming up. You've got a reasonable chance of staying on because this is what your doctors are saying, to saying, look, we accept you've got no work capacity and that's likely to be accepted, but you're not going to have an income as of, the 1st of July this year or whatever it is. So that was somewhat concerning as well in terms of these reforms.
And you just reminded me, Tyen, I had a client who received a termination notice at 130 weeks, and the grounds of termination were based on the old legislation, namely that she did have a capacity for suitable employment, and there were a number of jobs listed as her being capable of performing. And we had sufficient evidence to refute that, to say that she's got no work capacity indefinitely, to some weeks later receiving a new notice from the Workcover insurer to say that, in fact, she falls under the new legislation and she hasn't met the 21% threshold. So for those listening at home, if the termination period takes effect after the 31st of March, say, for example, they receive the notice in February, but their payments come to an end in May of this year, then that 21% requirement applies. Now, I do see one question from Michael. Michael, this doesn't impact on common law claims. This applies entirely to statutory benefits. Are there...
I was going to say thank you very much, gentlemen. That was actually really interesting, not that it wouldn't have been. If anybody has any questions, please unmute yourself and feel free to ask. Otherwise, I do have a couple of questions that came through from people who weren't able to make it.
Yes, of course.
Anybody brave enough to unmute? Nope. I'm surprised I'm doing this. So, so I have a question from a few case managers that weren't able to attend. Kathleen Goff, she wanted to ask whether you see these reforms as being a push to perhaps put more ownership on employers to introduce preventative measures in place to avoid or reduce mental health injuries?
No, I don't think the scheme reforms put any pressure on employers to do anything differently. But I will also invite Ty to share his thoughts.
There was some push in the last few years to introduce occupational health and safety regulations around the risks of psychosocial injuries in workplaces. As far as I understand, that's now been shelved around the same time as these reforms were pushed through. So they've turned their attention away, to my understanding, to regulating employers' obligations around psychosocial hazards. The big kind of carrot that they attached to these reforms was the introduction of Return to Work Victoria, which was an organisation designed to help injured people return to work. We've yet to see whether that changes anything. It's too early. That's in its infancy at this point.
No worries. And I have a question from Matt Coyle. He's asked, you mentioned in relation to GPs not being entirely trained in the DSM-5 requirements. Are there any of the legal panels or associations, things that people like yourself, I think, are on one of the associations, Sach? Are you petitioning to the VWA to ensure new requirements come out for the doctors so that they know what they need to do, given GPs are somewhere that injured people go to first when they get hurt?
I'm not aware of any at the moment. No, I on reflection, I mean, I'm part of the Law Institute's Workers' Comp Committee as well as the Lawyers Alliance, and that has been spoken about. But I think that would be a good idea. Ty, have you heard of anything from your end?
No, not particularly. I mean, there was suggestion that WorkSafe was going to reach out to their kind of registered providers to provide some, education by way of, booklets and that type of thing about these reforms. I mean, I can't comment about GP training around the DSM-5. My understanding is they are probably able to do it. It's probably more a time commitment and also just the nature of some of the diagnostic criteria that needs to be met, where it just can't be done at the initial consultation. It may be more prolonged in some cases. What I do know is WorkSafe and more broadly the TAC as well. They're trying to get more medical practitioners qualified to do the whole person impairment assessments under the relevant guides to try and reduce the backlog and the expected backlog that will come from these reforms as well. But yeah, I don't know about the questioner's particular concerns, unfortunately.
And those additional practitioners that WorkSafe are training up, they're assessing the entitlements on behalf of Workcover, on behalf of the insurers. But the people that medical professionals, our clients, go to first will be their GP. And historically, you go to the GP, you tell them what happened at work, the GP will write a certificate of capacity, detail in there that the injured worker suffers from a psychological condition. And then the assessment process will commence without any question as to whether the DSM-5 criteria has been met.
Yeah, amazing. Well, thank you so much for that, gentlemen. We do need to wrap up here. So thank you for sharing your expertise with us today, and thank you to everyone who did attend. I would also like to mention that Sach and Tyen did previously present a seminar with MAG on the assessment of damages in personal injury less than a year ago, which received over 400 views. So if you would like to check that out on our YouTube channel, let me know and I can send you a link. These two guys know their stuff. The recording will be sent out to you within a day or so. Other than that, if you guys have any more comments.
No, thanks for having us.
No worries. You have a great afternoon and we'll see you at our next seminar.
Thanks, Jess.
Thank
Thanks,
you.
everyone.
Thank you. See ya.